Start. A very good morning to respected principal, Sibsagar Girls College, Budhin Mishra sir, respected vice principal ma'am, Dr. Rita Bartokotogi ma'am, respected IQC coordinators, Sibsagar Girls College, honorable resource person, Dr. Anjumani Talukdar ma'am, esteemed colleagues, and my dear participant friends. I, Dr. Pranami Hande, on behalf of the Department of Chemistry, welcome you all to this webinar on intellectual property rights. With the increasing focus on innovation, research, and cross-border collaborations, the need to learn about intellectual property rights to safeguard inventions has increased among the students. Intellectual property rights has various verticals, including patents, copyrights, trademarks, design, etc. The foundational awareness regarding the rights of a creator needs to be developed in students from the school and college level itself. Students will grow and get into the professional world where they will develop and exercise IP rights. Hence, intellectual property rights has become a vital part of the academic curriculum. Now, in order to inaugurate our program, I would like to request Principal, Sibsagar Girls College, Budhin Mishra sir, to speak a few words and inaugurate the program. Over to you, sir. Principal, sir.
Thank you, Pranami. Good morning, everybody. Respected Vice Principal, Dr. Rita Bartokotogi, my colleagues, resource person of this webinar, and my dear student friends. I welcome you all to this webinar on intellectual property rights. It is a right given to person about creation of their minds. It is a vital legal impact of our creations, original terms. So it has various impact in the academic aspects also. So today our chemistry department, in collaboration with IQAC of the college, has initiated to hold this seminar on intellectual property rights, which will throw light on various aspects, both legal and other aspects. So I hope this webinar will be a very successful one and will give various informations to our faculty as well as the students. So with these few words, I declare this webinar as open and hope the success of this webinar. Thank you.
Thank you so much, sir,
Pranami,
for your encouraging words.
প্ৰণামী
Yes, sir.
হেৰি আমাৰ
Yes, sir.
হোষ্টেল আৰু ছায়েন্স কেম্পাছত কিবা চুৰি সোমাইছে, মই তালৈ যামগৈ, গতিকে মই ইয়াতে এৰিছোঁ দেই।
Okay, sir. Thank you for your gracious presence. Thank you. Thank you, sir. Now, may I now request Dr. Rita Bartokotogi, madam, to speak a few words and encourage us. Madam?
Okay, thank you, Pranami. Can you hear me? Am I audible?
Yes, ma'am, we can hear you.
Okay. Good morning, all of you. Respected Principal, Dr. Budhin Mishra sir, resource person of this program, Dr. Anjumani Talukdar, and organizers of this webinar, IQAC coordinator, Professor Ichinali Vyasuria, faculty members of chemistry, Professor Pranjal Rajkwa, Professor Pranavjyoti Barali, Professor Pranami Hande, Abhijit Barpujari, librarian of our college, and my dear colleagues and participant students. First of all, I'd like to thank the organizers for organizing this webinar on intellectual property rights, especially for creating awareness, creating awareness among the participants. I feel this is a very important issue for us. When we see the international scenario, we can see the International Intellectual Property Index. Our country, India, has secured a position of 40 at the lower line of the ranks among 53 surveyed countries. And the first rank goes to the United States. And the United States score is around 95.31. And can you guess what is our score? Our score is just 38.21. So it is very low in comparison to the other countries. It is true that in few years, India is improving a bit. But I feel that we have to do a lot to climb the ladder. Even in the patent granted list also, where China has a patent of around 4 lakh something, when India has patent hardly 13,000 something. So in this field, internationally, our country is lagging behind. And what I feel that we Indians are not so that we are not capable to get copyright. We are not capable to get trademark or entrepreneurship, patent, etc. Sometimes it is felt that because of, we can say because of ignorance, because of unawareness, and sometimes even reluctance, due to reluctance, maybe that we are lagging behind. So these type of programs are very, very important at this hour. And so I congratulate our organizers for organizing such a webinar, especially for our students, so that these webinar can motivate our students. Why only students? Even our colleagues, so that we can work towards betterment or improvement of our country's status. So with these few words, I wish you all a very successful completion of this webinar. But when I say successful, I don't only mean that 1 hour of this webinar. When I say successful, I want this webinar will motivate all the participants, especially the youngster students, so that we all can work hard for betterment of our country's position. So then only we will be able to say that this webinar is a successful one. So with these few words, I conclude my speech with all the best to all of you. Thank you, Pranami. Over to you.
Thank you so much, ma'am, for your motivating words. Now, before I move on to our resource person, here's a small announcement for the participants. A 5-minute interaction session will be there after the talk of the resource person. So I request all the participants, if they have any queries regarding the talk of the resource person, please feel free to communicate with her in this 5 minutes after the talk. And there will be a feedback link. A feedback link will be provided in the chat box after the talk. You have to fill up the feedback form, and then you'll be able to get the e-certificate. So without any delay, I'd like to move to our resource person. First, let me introduce her to all of you. Dr. Anjumani Talukdar Madam has been teaching chemistry to students of different colleges for the last 11 years. She has done MSc in chemistry and received her PhD from Guwahati University. She has completed postgraduate diploma in intellectual property rights from the Institute of Good Manufacturing Practices, India, that is IGMPI, New Delhi. She has a good number of publications in reputed international journals. She has published several scientific and food-related articles in popular Assamese magazines like Kantik, GNRC Saistho, Barao Thoro, etc. She has also a blog named Maverick, where she shares her interest on chemistry and food science and nutrition. She has also authored a book, Intellectual Property Rights, as per the CBCS syllabus of Guwahati University for BSc Semester 3 Skill Enhancement course. Now I request Dr. Anjumani Talukdar Madam to deliver her talk. Dr. Anjumani Talukdar Ma'am, you can proceed, please.
Please unmute. Hello, ma'am. Please unmute your.
Thank you. Thank you, Pranami. And good morning, everyone present here. It's for giving me the opportunity to be discussed here, my thoughts on IPR. I will try to discuss my thoughts here with best of my knowledge. Now, I am going to share some of my slides for your convenience. Please kindly wait a moment. Please confirm if it is visible or not. Is it visible, Pranami? Is it visible?
Yes,
Yes,
Anjumani Talukdar Madam, it is visible.
Yes.
It is visible.
Yes,
Okay,
yes.
let's start without any delay. Now, today the topic is the intellectual property rights, creating awareness about patents, copyright, and entrepreneurship. Now, when we talk about intellectual property rights, first we talk about the intellectual property. What do we mean by intellectual property? It is basically comprises of two words. One is intellectual and other is property. The intellectual, something is related to your intelligence, something related to your skills and your ideas. And property means something you own or your ownership. So in brief, something intellectual property means the creation of human mind, and you get legal protection for your innovation or your invention. So there are several examples for where whom we can get intellectual protection of intellectual property rights. So it can be a recipe. There are many. This is the recipe of biryani, where there are many types of biryani, and the creator get protection over here so that no one can copy and get legal monetary benefits. And it may be literary work, a book, a painting, or it may be a film, and it may be your own brands, so for which you can get benefits, and no one, you get protection so that no one can get unauthorized copy. Now, when we talk about property, properties are of two types, basically of two types. It is tangible property, which means has physical form. We can feel, we can see. Tangible property, examples of tangible properties are jewelry, car, buildings, lands, and intangible property don't have any physical form. It is only in our mind. The intellectual properties does not differ from any other property, as we can get monetary benefits from other property by selling it or by licensing it. We can also get monetary benefit from our intellectual property. Now, there are basically two major branches of intellectual property. One is industrial property and other is copyrights. There are four types of intellectual property: patents, design, trademark, and geographical indications are fall into the industrial property category, and poems, films, paintings, video, these are copyright, includes copyrights. Now, why intellectual property is so important and why it is recognized all over the world? And there are the few reasons. These are the reasons: to provide an intensive to individual of their new creations, to accord due recognition of the creator, and to make genuine and original products. Let us take an example. No one know J.K. Rowling before the creation of her Harry Potter book. But after publishing her book Harry Potter and making films, she is recognized all over the world, and she became a billionaire. Now this is the benefits you get if she do not copyrighted the Harry Potter, then this is not happen to her. Now next, to make genuine products, suppose you are buying a Puma label T-shirt or shoe in an authorized showroom of anywhere in India or world, you are getting the original products. I am mentioning authorized because you get, if you are not buying it from authorized dealer or authorized showroom, you are not getting. There must be a fear of getting the duplicate product. So these are the regions, so that it is accepted, IPR is accepted all over the world. Now, the history of IPR. When you look back, the history of IPR, it is created basically in European country. In 1873, an international exhibition for invention is organized in Austria, Vienna, where people from all over the world are invited to show their products or invention. But many foreigners refused to attend this exhibition because they thought that they are afraid that their idea must be stolen. So keeping in mind, many countries came together and decided to protect the industrial property by some legally. So in that and that's how in 1883 the Paris Convention is born. Now after that, to protect the literary and artistic work, the Barney Convention in 1886 is established. After that, to protect the trademark or related mark, registration of IPs internationally, registration of trademark, in 1891 Madrid Agreement is launched. After that, the United International Bureau of Protection of IP, that is BIRPI, it is a French acronym, is established, and after that it becomes a specialized agency named UPO, World Intellectual Property Organization, is established. And in 1974, UPO joins United Nations, and after that PCT, the Patent Corporation Treaty for filing patent internationally, is established. This is the history of IPR. So after to create relation between different countries through trade, one organization is created which is called General Agreement of Tariffs and Trade in 1947, which is a negotiation. GATT is a product of Uruguay Round Conference. After that, GATT transformed to World Trade Organization, and both World Trade Organization and WIPO are the specialized agency of United Nations. Then what did UPO do? UPO seeks development of balanced and accessible international IP system. It rewards creativity, and it gives economic benefit to the inventor. After that, UPO that trade related aspects of intellectual property right is generated. TRIPS is the most important aspects of most important agreement of IPR in respect to several respect of pharmaceutical IPR, because as we know, many developing country or developed country are generating this the pharmaceutical products, but the cost is too high, and it is not affordable to all. So TRIPS creates standard norms for all the country members of WTO, and it is generally decided two aspects of pharma IPR. Such as one is social aspect, that means it should be affordable, reachable to every people of the world, and other is economic benefit. It should not be give this does not give the free product. Actually, মানে এনেকুৱা হৈছিল যে ট্ৰিপছে আপোনাৰ ঔষধবিলাক সব কাণ্ট্ৰি পাবও লাগিব, আৰু যোনটো কোম্পানী সেই ঔষধবিলাক বনাব তেওঁলোকৰো ইকনমিক বেনিফিট হ'ব লাগিব. So TRIPS makes it clear that the pharmaceutical products should be easy access to public. Now, one of the first IPR is one kind of IPR is patent. Patent is generally gives to granted for the inventions, means it is granted by government. Means if you have an invention or if you have a formula, you are apply for the patent to the government, and government is giving a guarantee that your idea or your formula should not be copying unauthorized. It restricts copying of unauthorized selling or copying. Okay, but you have to give it full disclosure. মানে তুমি গুটেইখিনি দিব লাগিব, আধাকে দিব নোৱাৰা। গুটেইখিনি দিয়াৰ পাছত it will guarantee that your idea should not be stolen, your work should not be stolen by others, and it is given to the patentee for a certain period of time. In case of patent, the time limit is 20 years. After 20 years, it comes automatically to public domain, means everyone can use your work without your permission. If someone want to use your work before your patent period, then the person or the company should give you some benefit. Means basically this is called a royalty. So patent is given to both product or process. Means you can get the patent. India can get which company making this Covaxin vaccine, they can apply for the patent, so that no one can copying the no one can get monetary refund, the other country get monetary benefit from this Covaxin. Only India, the Indian company which created this vaccine can get the royalty. So, and again there is the process patent. Process means in which way the product is making. You can also get the patent is also granted for the part also. So in India there is a process of granting of patent for both product and process. Now, criteria for patentability. There are basically three criteria for patentability. First one is novelty, the second one is inventive stage, and the third one is capable of industrial application. Now, what does the novelty mean? Novelty means your invention should be new or novel. Means your work should not be published anywhere in that place where you are applying for the patent, should before filing the patent application. Otherwise, you are not there. Your work is not taken as a novel work. Now, inventive step means your invention should have a technical advancement before as compared to the existing knowledge. Now, this is, for example, taking this one. Before inventing these stamps, which has LED light on the wicket stamp, there are always a stamp, but it is difficult to detect the runout by everyone, because you cannot think, you have to check camera for the if ball hits the stump or not. But after this, when come to the LED stump in the cricket field, everyone can easily detect it, that if the ball is hitting the stumps or not. So this is an inventive steps of the invention. So who invented this idea or this creation, so he or she may apply patent for it. And third one is the capable of industrial application. This means your invention should have practical utility in day-to-day life or in industry. You are creating something and there is no practical utility of that product, so this type of product does not get patent. Now there are basically three types of patent. One is design patent, utility patent, and plant patent. So protection of any ornamental design of anything, means a shape of a bottle. Suppose you, for example, the bottle of Coca-Cola, design of a shoe, and some jewelry design, everything are patented. If it is new or novel, then you are getting a design patent. Then utility patent means this is a technical document to teach the public how to use a new machine, a new product, or new process, or a new system. So, and the plant patent means if you generate a plant with some non-sexual means, then you are also granted a patent is also granted for them. But genetically modified organisms are not fall into the category of plant patent. Next one is, this is the example. This was the manual egg beater, and this is the technical advancement of the egg beater. Before that, you can apply. Before earlier, it was operated manually, but after it is modified, and there is a electric it is functions as electrically. So you can apply for patent for this design, for the look, and you can also apply utility for patent for the how it is function. Okay, now you can, now here I am writing the provisional patent application. I am not going to discuss all this in very detail, but I just mentioned that provisional patent applications means you can apply for patent before filing the complete specification of a product. Means you are getting 1 year time, extra time to file complete specification of a product. Means if you know that, মানে তুমি গম পাইছা যে তোমাৰ মেচিনটোৱে বা তোমাৰ যোনটো ইনভেনশন হয় সেইটোৱে কাম কৰিছে, মানে এইটো ফাইনালি হোৱা নাই, কিন্তু তুমি তোমাৰ সেফ গাৰ্ডৰ কাৰণে যাতে কোনেও সেইটো একে টাইপৰ অকমান এডভান্সমেন্ট কৰি যাতে বেলেগে বস্তুটো বনাব নোৱাৰে, তাৰ কাৰণে তুমি provisional application, patent application file কৰিব পাৰা। আৰু for complete specification you are getting another extra 1 year, মানে extra within 12 months তুমি complete specification তুমি submit কৰিব লাগিব। Now these are the famous example of patent. Everyone know the Edison, Thomas Alva Edison. See, he has patented many of his inventions. One of this is the invention of electric bulb, and this everybody know the Three Idiots film. This is based upon the life of Sonam Wangchuk. The Amir Khan play the role of Wangchuk, and in the last part of the film it is mentioned that he has patented many of his inventions, and Japanese are looking for him. And this person, you also know, this is from our respected Uddhav Bharali sir. He invented the pomegranate দিছে, ডালিমৰ গুটি ওলোৱা মেচিন এটা আৱিষ্কাৰ কৰিছিল। সো যদি কোনোবা যদি কোম্পানীয়ে সাৰৰ বস্তুটো লয়, এই মেচিনটো অকমান মডিফিকেশন কৰি বনাই তেওঁৰ আইডিয়াটো লয় বহুত মাস কোয়ান্টিটি, দেন স্যার মাস্ট হ্যাভ গট সাম রিয়েলিটি, মিন্স কিছু পয়সা সারক দিব লাগিব যদি সারে এটু পেটেন্ট কৰিছে। নাও দিস ইজ আওয়ার স্যার, মাই mentor, PhD mentor, Dr. Dibakar Chandra Deka, professor and head of the department, former head of the department, chemistry department of Guwahati University. Now he is serving as a vice chancellor of Madhavdev University. He patented the isolation method of potassium carbonate of Kolakhar. Kolakhar traditionally we are using as a alkali, means baking soda যেটো potassium carbonate থাকে, কলাখারতো potassium carbonate থাকে। This potassium carbonate is responsible for the alkalinity of the product. So sir has isolated potassium carbonate from Kolakar, and he patented it. He has made 2 or maybe 3 patents, but this is his first patent. So he got this patent in 2008. So date of filing of patent is 2005, means after 20 years, at 2025, the patent is come to public domain, means everyone can use this method for isolation of potassium carbonate. Okay, means his patent will be off patented. মানে সবে ইউজ কৰিব পৰা হ'ব 20 বছৰৰ পিছত। কিন্তু কোনটো ডেটৰ পৰা ধৰা হয়? Date of filing the application, not date of granting the. There is a little bit confusion because granting date is 2008 and filing is 2005. So 2025, not 2028, 2025 his patent will be off patented. Okay. Now patent have territorial jurisdiction, means you can apply for patent nationally or internationally. মানে তুমি যখন দেশত আছা তাতে পেটেন্ট এপ্লাই কৰিব বা টেৰিটৰিয়েল বুলি কয়, মানে জিওগ্ৰাফিকেল স্পেসিফিক জিওগ্ৰাফিকেল এৰিয়া you can apply for patent, and internationally of your country of interest যদি তুমি apply কৰিব লাগে, then you have to apply with PCT, means patent corporation treaty through যাব লাগিব। মানে ইন্ডিয়া যোনটো পেটেন্ট হৈছে, maybe it should not be granted patent for patent in USA. Okay, it has territorial jurisdiction. So now is everything patentable? মানে যিয়ে বনাইছা সেইটোৱে পেটেন্ট হ'বনে? তো সেইটো the answer is no. Section 3 and section 4 of Indian Patent Act said which are not patentable. And section 3 A to P, I'm not going to discuss here elaborately. And it is mentioned that certain things are not patentable. And section 4, invention related to atomic energy is not patentable. So no patent shall be granted in respect of invention of relation to atomic energy. Means you are creating an atom bomb, you are not getting patent. Government is not going to grant a patent for you because it is related to our national security. And this type of work should not be patented. So patent application can be filed online in India by an inventor or his assignee. Assignee means you are legal representative. You are inventor, but you are legally authorized someone to apply patent. So patent to where you can apply, there is a website called www.ipindia.nic.in. You can apply for this. Now I am going to discuss something about section 3D of Indian Patent Act. This is a historical act, amendment of Patent Act in case of pharmaceutical product. Means this says that any mere discovery of new form or a known substance which does not result in enhancement of the known efficacy of that substance, of that mere discovery of any new property or new use for a known substance, or of the mere use of a known process, machine, apparatus, unless such known processes result in a new product or employs at least one new reactant, is not patentable. মানে সব কি হৈছে এখিনিত হয়তো কথাটো বুজি নাপাবা, মই ভালকে কৈছো। Suppose you are taking an example of quinine. Quinine is a drug used in the treatment of malaria. So chloroquine is the product, is a derivative of chloroquine, and is found efficacy almost 90% of efficacy, and the company which is making this chloroquine has granted patent for it. So they are getting patent for 20 years only, and they are getting royalty, they are getting economic benefit. So before completing the 20 years, মানে 20 বছৰ হোৱাৰ আগে আগে তেওঁলোকৰ পেটেন্টটো 20 বছৰ হোৱাৰ পিছত সবে ল'ব, অকল তেওঁলোকে মনোপলি কৰি আছিল বজাৰত। সেইটো কৰিবৰ কাৰণে তেওঁলোকে কি কৰিছে, they again created a molecule of bromo derivative and found that it is of 92 or 93% efficacy, and they again apply for the patent. So eneka horile only one company is getting the benefit, other one always lagging behind. So this is the amendment that any new discovery, and tomar jodi kono polymorph isomer, kono salt, this of a known substance already is patented, to ebilake patent na pai. So this is same thing is done by the company Novartis. This is a Swiss company, and they have granted patent of this drug, anti-cancer drug. This is a Glebac, and its original name is generic name is imatinib mesylate. So they got granted patent for this drug, and they are enjoying their benefit. The cost is too high. So Indian company বিলাকে জানিও এটো বনাব পাৰিছিল যদিও তেওঁলোকৰ পেটেন্ট আছিল কাৰণে নোৱাৰিছিল বনাবলৈ, জানে যদিও প্ৰসেসটো জানে বা প্ৰডাক্টটো জানে কিন্তু বনাব নোৱাৰে, দামটো কিন্তু বনাই চালে যে বহুত কম খৰচতে হয়। So they, before getting after off patented, মানে যেতিয়া 20 years হোৱাৰ আগত they again said that the alpha isomer is of this compound has 30% enhanced efficacy of that the previous compound, and they again apply for the patent. But the Indian Supreme Court rejected their plea because there has a protest everywhere that they are getting the monopoly, they are enjoying monopoly. So the Indian Supreme Court rejected their plea to patent their drug. Okay, this is the patent evergreening or off patent case, famous example. Now, why we file a patent? To protect our invention, to block your competitor, to create a fence around your business idea, to improve company valuation, raise funds against patent. So patent, these are the main reasons. So you can file a patent. So you have to file a patent. This is an example of patent free. When Volvo, one of the engineer of Volvo has invented the safety belt, but the company patented it. But after some time, he make it patent free so that every company can make the belt, because it is related to life-saving work. If it is patented by the company, then no one can make this belt at least for 20 years. So patent offices of India operates from different part. Here Mumbai, Chennai, New Delhi and Kolkata. These are the 4 patent office in India where you can apply for the patent. Not these are the respective states where the people from these states can apply for particular region, particular offices. So if we are Assam or Northeast, you cannot apply patent for in the office of New Delhi. You have to you have to file patent application in Kolkata office only. So these are all about patents. Now I am coming to copyrights. So copyrights are legal rights on protecting the author's work. Here authors means it may be anyone. It may be a writer, an artist, a designer, a dramatist, musician, sound recording of producers of sound recording, etc. Means you have legal rights. Just there should not be an unauthorized copy of your work. And these are, in simple terms, copyright means right to copy. Here is the example of copyright infringement. What do you mean by copyright infringement? Means unauthorized use. There is no permission before using your work. So this is the famous example of copyright infringement issue when Jubin Garg, everyone knows that Jubin Garg's Ya Ali song has controversy that it is the original song is from an Arabic song, and Pritam, the music composer, has copied it and does not even give the original source where it is come from. So copyrights gives the protection of expression of idea, not the idea itself. So idea তুমি copyright তোমার মাথাত বা মুৰত থাকিলে হেতু তুমি copyright কৰিব নোৱাৰা. It should be expression of idea, because it should be inscribed, মানে tangible format আহিব লাগিব. মানে it may be of any book, it may be written in any stones or any form of CD or DVD. তো তাতেহে তুমি কপিৰাইট পাবা. তোমাৰ আইডিয়া তুমি গান এটা ভাবি গৈ আছা আৰু হেইটোতে তুমি হেই ভাবা গানটোত তুমি কেতিয়াও কপিৰাইট নোপোৱা. Okay, it should be written somewhere. So what do you mean by fair use of copyrights? So fair use of copyrights means ভাল কামৰ কাৰণে ইউজ কৰিছে, যেন something you are using in teaching purposes of some books you are copying some lines from the books for notes. These are not copyright infringement issues. So news reporting, criticism or comments, and making parody of a song, it is not the example of copyright infringement. So this is the famous example of fair use of copyright when this picture of Barack Obama, picture on the left side is Barack Obama, is taken by the one photographer of Associated Press, and one street artist has some taken this photograph and had some modification, and it is used in the campaigning of Barack Obama presidency presidential election. But after some time, the Associated Press has shoot the street artist, and the street artist has explained that it is meant to be fair use. He is not getting any monetary benefit. We are not getting confusion, not creating confusion to anyone. Now, term of the copyright. Every IPR has some term. So, for copyright in India, we have terms of 60 years plus lifetime of the author. Means lifetime of the author, and after the date of the that we get up date, and plus 60 years we are getting the copyright protection. And for other country, most of the countries, it is lifetime the author and plus 50 years. And in Europe and USA, it is 70 years plus lifetime of the author. So next one is industrial designs. Industrial design, the design word is just described that it may be a feature of shape, configuration, pattern, ornaments, composition of lines, color, maybe 3D pattern or 2D pattern. This falls into the category of industrial designs. Protection given only to the appearance, not for how it functions. This is the example of electric jug. Means there are several types of electric jugs. It is modified for, but you can get protection for the design, not in case of industrial design. But you are getting, if you apply for utility patent, you get how it functions. For how it functions, you should apply for the utility patent. Another one is trademark. Everyone is using trademark from morning to morning to night in her day-to-day life. So trademark may be a symbol, maybe a word, a phrase, or a combination of this. Or means it should be represented graphically, and it should be capable of distinguishing one product from those of another. So the key features of trademark is it should be distinctive. That your product should be different from others and should not be deceptive. It should not mislead anyone. These are the famous example of trademark. When you see this sign, you just know that this is the product of Nike. This is a trademark. This is Apple trademark, and these all are using. So these are symbol. Only the letter is getting the trademark protection. This is the color of Coca-Cola is always using the red color. So see, it is getting the color protection. Then the phrase. See this famous phrase, a lot can happen over a coffee. If you see the line anyways, you know that if you're not, it is not visible, then by seeing this phrase, you can detect that this coffee is from CCD. So you can get protection of sound marks also. Then the starting tune of Nokia, you can get protection over there. So, how do you know a symbol or a phrase is trademark? The word TM is written. Here in Gmail, there is a TM. And in Subway also, there is a TM is written. Why should we use this? Why should we register trademark? So, trademark registration is necessary because to unfair competition of your competitor. So there are the categories of trademark. Trademarks are of 5 categories. Here it is generic, descriptive, suggestive, arbitrary, invented, or coined. So here's the example. Generic means you can get simply the name and services of the product. So generic, you can, if you are starting a brand name salt and you are selling it, it is pretty much easy for anyone to detect that it is salt. Other salt or sugar, these are generic names, and this cannot be used as a brand name. Next one is descriptive, means this the name itself describes the product quality or characteristics. Means whenever you talk about fair and lovely, it means lovely means it is girl, it is for girl, and fair and handsome means it is for boys. So the product itself describes, the name itself describes the characteristics of a product. So Netflix, again this is the example of suggestive trademark. This means this give you some idea about the product or services. Means net something flicks means it is doing something internet related to internet. You have to guess. And another one is arbitrary, or this means the dictionary meaning of that product is not related to, dictionary meaning of the word is not related to product identity. Means blackberry is a fruit, but you are using it blackberry in a mobile phone brand. So whenever you talk about blackberry in mobile phone, you should not, it may be anything of that blackberry product. And this is another last one is invented or coined. It have no dictionary meaning and no connection with products. Means কিবা মানে তুমি মন মৰ্জি টাইপৰ, তুমি কিবা এটা ভাবিছা আৰু দি দিছা নামটো. So the strongest one is invented or coined. It is very difficult to copy and it is very easy to protect. So whenever you start, you are starting any startup and you are selecting a trade name, you should be very cautious, because if you are using any generic name or descriptive name, your trademark is easily copied and you are not getting registration. So before applying for trademark or choosing a brand name, you should search for it. Next. The function of trademarks are identity. There are 4 functions of trademarks. It identifies the goods and services and its origin. It guarantees its unsensed quality. It advertises the goods and services. It creates an image for goods and services. It's why, again, what is the difference between TM and R letter? So in many brand or logos, you are seeing the symbol is TM, and in some cases you will notice some R symbol. So R means registered, already registered, and TM means trademark you have applied. Means you are applying for trademark registration. When you file an application, the office itself giving you an acknowledgement receipt. So after that, you are eligible to write the TM word. Okay, but your trademark is not registered with. And after 18 to 24 months, if there is no dispute or no complaint of your logo or your phrase, then your trademark is registered and you are eligible to write the R word behind your or in between your logo. So these are the trademark infringement cases in India. Everybody know, when you are going to buy Oreo and this is Fabio, all are the colors, the styles are similar. This is, you are misled whenever you are getting want to buy the Colgate product and you are buying the Ozonta product, because they are deceptively similar. It can mislead anyone. So this is that trademark infringement. So unauthorized using, if is copying this unauthorizedly, then the Colgate company can sue the Azanta company. Is now how we get a trademark. Often we get a trademark is get through registration. It is in India, it is first to file system. You have to pay a minimum fees for registration, and there are 45 classes of goods and services. It is called NICE classification. If your product is a substance or good, then you have to apply for 1 to 34 goods and products. There are categories. And if it is services, service means Suppose any mobile services, Airtel, any bank services, for this logo you are applying, then you have to apply in 34, number 34 to 45. Online, and now we can apply registration of trademark to online. Now the question is the trademark registration is necessary? Generally it is not, because whenever you are making a brand, suppose you are making, to me, it's a Asara brand, simple example, and in your territory, your local geographical area, and you are making an Asar brand name, some brand name XYZ, then your sale is good, people are now recognizing you that this is the brand she is using or he is using. But in Guwahati also, or in some other part also, with same name, someone is also selling the goods and goods. Then what happened? Your customers is declining. You are not getting the actual benefit. So but your trademark is or not registered. So you cannot file case them and go to the court. If you are going to the court, then you have to submit several proofs that this is the original one. So যদি ৰেজিষ্টাৰ থাকে আগৰ পৰা, তেতিয়া তোমাৰ এইবিলাক কৰা মানে প্ৰব্লেমছ বিলাক কমাই দিয়ে। তুমি লগে লগে সেই যোনজন বেলেগ মানুহে এইটো ষ্টাৰ্ট কৰিছিল তাক চু কৰিব পাৰা। Okay, that's why registration is not necessary, but it gives you certain advantages. So next one is geographical indication. This is another type of IPR which is relation to some territory or geographical location, because many agricultural product has some influence, climate influence. It is influenced by the geographical climates and others. Suppose this king chili produced in Assam or Northeast is different from it is produced. Even we cannot grow this chili in Bengal, because there is an influence of the soil of Assam or Northeast. This is the Zoha rice. This is only found in Assam, not in all other part of the world. So these type of products are protected under the GI, means geographical indication for IPR. So simply GI means, what do you mean by GI? It is a symbol or sign of which is indication of product. It has a specific geographical origin. It can identify the goods and product of that geographical area. It may be used to some natural products, some agricultural product, or manufactured product. These are the product which has got geographical indication. Means this is Zoha rice, this is Kumal Saul, this is Karbi Anglong ginger, this is Tezpur Lisi, Muga silk, everyone knows. It is only produced in Assam, and and this is the famous Assam tea. And this is Darjeeling tea, and this is Basmati. It is West Bengal got geographical location over here. And this is Kashmiri saffron, means it has something relation to its territory. And everyone thought that before getting Rasgulla GI, the Rasgulla, I also thought that it is because it is famous as Kolkata Rasgulla, but Orissa, the original recipe is from Orissa. So Orissa got the geographical indication for Rasgulla. So what happened when we does not protect geographical indication? Because it has, you should protect geographical indication, because our products, with our products, sentiments is related. Because when it is few years back, it is in news that Assam silk is copying Banaras, some mixed with something, because Assamese pat mekhala sadars differ from regular saris in land, braid, design and motifs, and people are burning the product. It is also in news. Means they are copying our product and using some other product, and it mislead the consumers, and the original producer suffers damage or loss. So if it is protected under geographical indication, some marks, then it cannot be copied. So what is the benefit of geographical indication? It confers legal protection. It prevents unauthorized use of registered geographical indication by others. It promotes economic property. In case of and any product is related to some rural development, it boosts an economy, and it is an important component of product pricing. Suppose you are buying an Assam silk from Assam, original Assam silk, its pricing is different, and if you are getting the in the imitation of the product, you are not getting the exact price of that product. So these are the examples of some GIs. This is the gamosa. The gamosa with both দুইফালে ফুল থকা গামোচা, অসমৰ গামোচাই GI ইণ্ডিকেট পাইছে। এইটো পোৱাৰ পিছতে অসমৰ গামোচা বহুত পপুলাৰ হৈছে। মোদী, আমাৰ প্ৰধানমন্ত্ৰী মোদীকো বাৰে বাৰে গামোচা লোৱা বিভিন্ন অংশগ্ৰহণ কৰা দেখা গৈছে। This is the Alpense mango. It is from Kankan. This is Tirupati laddu. This is the famous turmeric of Meghalaya, which gets geographical indication. And this is the Darjeeling. The photo is taken itself by me, and I am here in Darjeeling, and I have got the opportunity to click this photo whenever I visit the tea garden. And this is the first product of India to get the geographical indication. And the geographical indication is not only limited to agricultural product. It also gets the handicraft product of their territory also can get GI. This is Kolhapuri sapple, Nagpur orange. This is Madhubani painting, and this is the Kedarnath chicken of Madhya Pradesh who get geographical indication. And this is another IP is the trade secret. Trade secret is basically a formula, a pattern, and physical device which should not be disclosed to anyone. Means it is a secret. It should be confidential. It is a confidential information. So when it is qualifies for trade secret, it should be any secret it should be commercially valuable. It should be known to a limited group of person, and this person মানে তোমার এমপ্লয় যদি কোনোবা কোম্পানির এমপ্লয় যদি জানে, তো it should be a limited group of the secret should be a limited group of person, and the persons are legally binded so that it could not disclose to anyone. So these are the famous trade secret example. So KFC, everyone knows the KFC chicken. The 11 half spice mixed masala used in spices masala used in KFC to prepare KFC chicken is known to everyone. It is a trade secret. The creator of this recipe, Colonial Sanders, it is in his head only. After that, he eventually write it in an handwritten copy is set in the safe in the Kentucky, and it is disclosed to some employees, so that and thus these employees are legally bounded not to disclose this formula. Again, here it is also the famous example of Coca-Cola. So no, it is known to all that the Coca-Cola formula is not known to everyone, and the Coca-Cola company itself, they are not going for patent, because patent, when you apply for the patent, you have to disclose what is there in the product. So পেটেন্ট কৰাৰ লগে লগে বাকি বেলেগ মানুহ হয়তো পাব্লিক ডমেইনত আহি গলে মানুহে গম পাই যাব যে কোকা-কোলাৰ ইনগ্ৰেডিয়েন্টস কি আছিল। সো কোকা-কোলা ডিসাইডেড টু কিপ ইট ইন এ confidential as a trade secret. And the famous sauce of McDonald's burger sauce, and this is the mouth freshening Listerine. This formula is also a example of trade secret. And this is the movie where you can relate this movie to trade secret. लिखा है 4 आने का मुर्गी 2 करोड़ का मुनाफा. Means this person, they have a family restaurant or dhaba. If someone is watching the movie, then they must know. Then he is preparing a chicken recipe in his dhaba by applying some of his secret ingredients, but it is not disclosed to anyone, not even his family. After a few years, many people come here to buy his dhaba, not because of the dhaba, not only for the recipe. Many people are giving many money, but the person is not going to sell this. This is special chicken khurana recipe. This is the famous example of, you can say that it is also an example of trade secret. So So how can you evaluate IP? These are the process. How can you evaluate IP? So if you have an idea, you have innovation, then you are making an invention, then you can apply for patent. Idea, then you are expressions, maybe in written form or in other form, you are getting a copyright registration. Even idea, quality, identity, then it is applied. Then again you are applying for trademark registration. Idea only for appearance, you are getting for protection for that particular design. Then idea, keep it confidential, no disclosure, it is work as a trade secret. So these are the IPR legislation in India. There are after several amendment and some other issues, then the first law of India for IPR is the Copyright Act 1957. After that, the Patent Act 1970 is come. The Trademark Act is came in 1999. The Geographical Indication and Registration of Protection Act is also came in 1999. The Design Act is established passed in 2000, and the Semiconductor Integrated Circuit Layout Design also came in 2000, year 2000. And there and various amendments are there now till date. I am not going to mention here. So validity of IPR, patent is valid up to for 20 years. You have to renew it. You have a mandatory renewal. If you are not renewing it, it is automatically came to public domain. Trademark lifelong protection is getting for trademark, but you have to renew it after 10 years. Design or initially for 10 years, then again extra 5 years you are getting. And for copyright, 60 years in some in India, and in some other countries it is 50 years plus lifetime of the author. No renewal is required. And for geographical indication, it is lifelong, but you have to renew it for every 10 years. So these are the office. That IPR is fall under Ministry of Commerce, Department of Industrial Policy and Promotion. Then for all this IPR, patent, trademark, GIN, only one controller general is found. It is regulated by different territory: patent and design office, trademark registry, GI registry, patent information. And basically I have already mentioned there are 4 states here, 4 locations: Kolkata, Delhi, Mumbai and Chennai. For trademark registry, another is Ahmedabad. For GI registry only, it is Chennai. You have to apply GI in Chennai. And PIS, it is called Patent Information System, Rajiv Gandhi National Institute of Intellectual Property Management. It is located in Nagpur, Maharashtra. So these are the organization structures for IP. You can get. Now, why student must know about intellectual property rights? Already Pranami has mentioned in the earlier section that IP makes you, for if your protection go for IP protection, it provides better collaboration and funding. Nowadays, their cross-border collaboration is here, and it creates safeguards to students' inventions. Now, research and development, for commercializing your inventions, your startup, to get competitive advancement, you should protect your intellectual property. Now, student integrating nowadays from school level only, by national implementation, if national education policy 2020 is implemented, there is a vocational skills training in the school level also. But because in earlier days of life of earlier days, in school days, now students are developing some coding and other things, and they are project, they are doing good things. So if they know what is IP and why you need IP protection, they should be beneficial, because they are going to enter a professional world after completing their schools. And if they know during their school days, they are getting benefit. So CPAM, the creation of India, creative India and innovative India. Now government of India is launching many things: Startup India, Make in India scheme. So CPAM, IP promotion, sale for IP promotion and management, Department of Industrial Policy and Promotion, they are also creating awareness among students for IPR protection. So these are all about IPR. Hopefully, I think I have discussed something important here, and someone going to benefit here with my knowledge. So now the career opportunity. So what is the career in IP? So patent. You can work as a patent as after completing your BSc. Okay, so BSc and it science, any science graduate can eligible for patent design. It is exam that the exam is conducted by IP India. It is a government job, and also for trademark agent you can also apply. You should not have any IPR means law so you have a law kiba lagibo neki law nalage asalate. So you should after BSc you should apply for patent agent. So মানকে এই ipindia.com ত গৈ যদি চোৱা তাত পেটেন্ট এজেন্টৰ এনাউন্সমেন্ট দিয়া থাকে হেতু চাব পাৰি তাৰ কাৰণে কোনো IPR কোর্স কৰিব নালাগে only your knowledge from your science আৰু IP Act IPR ৰ কিছুমান কথা পঢ়িব লাগিব কিবা কিবি আহিব not too much from that. Again, another opportunity is patent exam. After completing your master's in science, this is also a government examination conducted by the Department of Promotion, DIPP. Age limit is 35 years. This is a very good job, and this opportunity, and its pay scale is also very good. You can also work as a patent analyst from any private law firm. You need not, as I mentioned, you need not have to should have a law degree for applying this examination. So one can apply for patent attorney if he or she has a law degree. Patent attorney, just like advocate, they are just showing that they are just patent litigation cases are handled by this patent attorney. In any company, you can also work as a patent attorney. So this is all about from my side. Now I am going to talk about my book. It is my book published here. This book is some basic concept of intellectual property rights I have prepared. It is prepared in very, you can say it a notebook actually, because it is prepared for undergraduate students, and but other people can also, if interested people can also get benefited from it. If you have interest in IPR, and you can go through my book. For context, you can contact details are given here. And I have running a blog called explanation by a at wordpress.com. You just whenever you, I'm going to mention here that whenever you trust expansion, I have not, there is no a here. Just if you explanation you are typing, then it is not coming. My blog is not coming. And I saw here thoughts on my knowledge on science, chemistry, food and nutrition, and some interesting mouth-watering recipes. You can go through, if you are interested, you can go through my blog. This is all from my side. Thank you. Hello.
Thank you so much, Madam, for throwing light on intellectual property rights. With diverse examples, we have lucidly explained about copyrights, patents, uh, trademarks, and I hope our students and all our respective participants have been highly benefited by your talk. Now, the session is open to the participants for interaction. If the participants and our dear students have any queries, please feel free to ask them.
Should I stop sharing? Stop presenting?
Yeah, please stop.
Okay. I'm stop presenting now. If anybody have any queries, please come forward. I am trying to give my answers from best of my knowledge. There are many students I'm seeing here.
Yes, students, if you have any queries.
Hello, ma'am.
Yes, Ansi.
Ma'am, can you hear me?
Yes, we can hear you.
Ma'am, my question was that you are telling about patent evergreen, na? So in that the company which is applied for the patentship right, he will get the patentship for whole lifetime?
I'm not getting the question. Actually, you are asking that if any company is applying for the patent, something related to that.
Yes, he will get the patentships right
Yes,
for
yes.
his whole life.
If you individually invented something, then you are applying for the patent. Then you are the real. You are getting the royalty, and you are an employee of that company. Then the company is getting benefit from it. Okay, this is the difference. Am I clear?
Yes, ma'am.
Thank you.
Hello, ma'am.
Yes.
Ma'am, am I audible?
Yes. Yes. Yes.
Okay. So, ma'am, I'm a postgraduate in physics, and currently I'm running a small business in handmade jewelry.
Okay.
So, ma'am, I want to know that suppose I'm innovating a design, and
Yes.
lately I have seen that people nowadays like ready-made designs and do not want to think of their own. So,
Okay.
what happens is that recently মোৰ অলপমান ডিজাইন তেনেকৈ ৰিক্ৰিয়েট হ'ল বা হৈছে মই দেখা পালোঁ চ' মেম কথাটো হ'ল যে মই এটা বছৰত মেবি 50 বা নিয়াৰ এবাউট 50 ডিজাইন মই উলিয়াওঁ চ' হোৱাট ইজ দ্য প্ৰচিডিঅ'ৰ ডেট মই গোটেইবোৰ ডিজাইন একেলগত কপি কৰিব পাৰোঁ বা এটা এটাকৈ কৰিব পাৰোঁ আৰু মেম যেতিয়া আমি এটা ডিজাইন এটা মই ক্ৰিয়েট কৰোঁ তেতিয়া লগে লগে সেইটো মাৰ্কেটত পাব্লিছ কৰি দিয়া হয় কমাৰ্চিয়েল পাৰ্পজত চ' মেম এনেকুৱা কিবা কথা আছে নেকি যে মই এপ্লাই কৰাৰ পিছত পেটেণ্টটো ফাইল কৰাৰ পিছত গ্ৰাণ্ট নোহোৱালৈকে মই সেই বস্তুটো কমাৰ্চিয়েল পাৰ্পজত পাব্লিছ কৰিব নোৱাৰোঁ
নাই তেনেকুৱা একো কথা নাই তুমি কমাৰ্চিয়েলি ইউজ কৰি থাকা অলৰেডি তুমি ৰেজিষ্টাৰ নকৰাকেও বা ইন কেছ অফ ইউ it is going to the trademark not in the patent actually it is not your machine design na তোমার কি হবো তুমি এপ্লাই কৰি থাকিব পাৰা but you have to think that তুমি যদি ৰেজিষ্টাৰ কৰা পাছলে এটা তোমাৰ সুবিধা হ'ব কিন্তু এতিয়া তুমি মানে তোমাৰ যদি কপিও কৰিছে ডিজাইন বিলাক তুমি কাকো ক্লেইম কৰিব নোৱাৰা why are you doing this মই অলৰেডি ইউজ কৰি আছো পাৰিবা কিন্তু তোমাৰ কিছুমান proof লাগিব so you always keep in mind that you are doing something original and you are keeping something just a receipt তুমি ধৰা জুৱেলাৰী ডিজাইন এটা কৰিছা হ্যান্ডমেড ডিজাইন তুমি যেটা রিসিপ্ট বা কিবা কৰিবা তাত তোমাৰ পার্টিকুলার কিবা এটা which is only for you you are using only by you তুমি সেই রিসিপ্ট খনত তাত এটা লোগো টাইপৰ কিবা এটা দিব পাৰা so that it can be used as a proof for further ঠিক আছে
okay মেম একচুৱেলি মই সুধিব বিচাৰিছোঁ মানে ট্ৰেডমাৰ্কটো যদি মই লগো বা মোৰ কোম্পানী নেমটোত লওঁ চ' মোৰ ডিজাইনবোৰ বেলেগকৈ মই পেটেণ্ট ল'ব পাৰিম নে নাই প্ৰত্যেকটো জুৱেলাৰী ডিজাইনৰ কাৰণে মই পেটেণ্ট এটা ক্লেইম কৰিব পাৰিম নে
সাৰ্ভিসৰ কাৰণে ক'লো নহয় মই অলৰেডি যে 1 to 34 গুডছ মানে আছে ন ক্যাটাগৰিজ আছে তো তুমি যেতিয়া এপ্লাই কৰিবা প্ৰত্যেকটোৰ কাৰণে তুমি এপ্লাই কৰিব পাৰা কিন্তু you have to file different application and you have to pay different registration fees প্ৰত্যেকৰ কাৰণে তুমি বেলেগকৈ তুমি registration fees দিব লাগিব
okay ma'am thank you
welcome
Any more queries? Yes, Dr. Anjumani Talukdar ma'am, yes. I have one question. Yes. Suppose we have isolated some novel compound, yes. And if we have already published, suppose we have already published in a reputed journal, so is it possible to file a patent after that?
It is not possible because if you I have already mentioned that your work should be novel. When you published it, it is not fall into the criteria of novelty because you are giving copyright to that journal because only the journal can do that thing, but you are not going to grant patent for it. Okay. Before publishing in a reputed journal, we should, I have already mentioned the provisional application. There must be a provisional application. তোমার গোটেইখিনি বস্তু নহওঁতে তুমি এবাৰ provisional application কৰি তুমি গম পাইছা যে it has something মানে কিবা ওলাব ভাল result ওলাব তাৰে before publishing in a journal you should apply for patent. Okay,
that is for provisional patent. Thank you.
anything
Now also any more queries? I think madam has shared her email ID in one of the slides. Okay, I'll share with you her email ID. If you have any queries, you can ask her, communicate with her via the email ID. Now I think one of our students, Astha Begum from 6th semester, Department of Chemistry, she wants to say something.
okay.
Astha Begum.
Thank you, Dr. Anjumani Talukdar ma'am, for
Thank you.
this informative presentation. It was a pleasure to have you with us. We have gained so much knowledge about intellectual property rights. We have also learned about copyright, patent, trademarks, IPR, importance of IPR, history of IPR, and I would like to thank our department respected teachers for organizing such an amazing program. Thank you again.
Thank you for everything. Pranami has done a great work. It's not audible.
Thank you for sharing your vast knowledge about IPR in a nutshell. And you have given diverse examples and made IPR understand in a lucid manner. Thank you so much. Now I request Professor Pranab Bharati sir to offer the vote of thanks. Sir, over to you.
Well, Pranami, am I audible?
Yes, sir. You are audible.
Okay. Well, wait a bit. Well, respected Principal Sir, Vice Principal Madam, Honorable Resource Person Dr. Anjumani Talukdar Madam, my dear colleagues and my dear students of our college, also from other institutions, and also present distinguished participants. And it's my privilege to propose the vote of thanks on this special occasion on behalf of Department of Chemistry, Sibsagar Girls College. Well, first and foremost, I would like to thank our beloved Principal Sir, Budin Mishra Sir, for the inauguration of the webinar and also for his valuable space. Thank you, sir. I thank Dr. Rita for giving us time to grace your cousin and also for her valuable, informative space. Thank you, Rita ma'am. Now, I want to express my heartfelt thanks to our Honorable Resource Person, Dr. Anjumani Talukdar, for her beautiful and interactive presentation on the topic intellectual property rights, creating awareness about patents, copyrights, and entrepreneurship. The topic is very important, I think, nowadays, and very relevant for students. A research person, Honorable Research Person, explained beautifully the topic. I'm sure that all the participant students and all the participants, I'm sure that will be benefited a lot from her valuable and effective presentation. Thank you, madam. We hope we will get you again in future in our such type of different programs. I expect you to participate in another programs in future also from to us. Then I'd like to thank our faculty members of our college for giving us their valuable time to grace the occasion and also for their support. I'd like to thank Mr. Abhijit Borpudari, librarian of our college, for giving us full technical support and related all other helps. Thanks a lot, Mr. Abhijit Borpudari. I'd like to thank IQSC Sibsagar Girls College, IQSC coordinator, deep journalist Sahoria, and Dr. Kaur for their support and active participation in the program. Dr. Kritanjali Kaur for their active participation. And I thank all the distinguished participants present here, student participants from our college and also from other institutes for their kind participation in the webinar, which has made the program a grand successful one. Once again, I would like to thank you all. Thank you. Now over to Pranami.
Thank you, sir. With this, I'd like to conclude the webinar. Thank you so much. Thank you.
Thank you so much. We can leave now, na? Sure.
Thank you.
Okay.
Thank you, everyone.
Thank you, Pranami, and thank you all for attending.
Thank you, madam.
অকমানো যদি কাবাৰ কিবা লাভ হয় লেকচাৰৰ পৰা, I will be very much
Sure.
happy.
Your
Thank you,
speech will
students.
benefit.
Contact you.
Yes. The young students,
Everyone is
youngsters.
benefited. Thank you.
Okay. Thank you.
And we are expecting in future
Thank you,
programs
ma'am.
also related
Thank
to
you,
IPS.
ma'am.
Thank you, ma'am.
Thank you, ma'am.
Thank you.